Most people think of a fight as probably resulting in a misdemeanor charge, but in Wyoming, a fight can quickly turn into a felony. This is Christina Williams with Just Criminal Law.
And David Mann, legal storytelling specialist. Well, I'm always interested in a good story. So, how does a fight turn into a felony? You'd think it would be never get to that level.
Right. So if you're having a disagreement with somebody and it turns physical and there's shoving and pushing and maybe some slapping, and perhaps just a punch that doesn't carry a big impact, then you're probably looking at a misdemeanor battery. However, if you throw a punch and you have too much force behind that and you break somebody's nose, or a lot of times what we'll see is a broken eye socket, that one punch can land you into a felony charge.
So, would we call that serious bodily injury that you have caused in your fight?
Right. Serious bodily injury includes broken bones, whether it's the nose, and my son being a wrestler, I know how easy it is to break the nose. Or, like I said, one punch. But sometimes you don't break a bone, but maybe someone loses consciousness. That is, they suffer a concussion. That's also serious bodily injury. I've even seen these situations where somebody gets a small brain bleed, and the prosecutors consider that very, very serious.
Yeah, it's really, it sounds like it would be. So, all right, so that's one way that it's distinguished as a felony. What's another one?
If you use or even just threaten to use a deadly weapon. And so, when people hear deadly weapon, they typically think that's a knife or a gun. However, I've seen all sorts of things be considered a deadly weapon by a prosecutor. For example, a bat. So you can just bring a bat to a fist fight and you threaten to use it, put that person in fear, and that's a felony. Or a beer bottle, a tire iron, all these things that aren't typically considered weapons, but when threatened to be used or when actually used, the prosecutor qualifies them as a deadly weapon.
Well, that's kind of actually interesting to think that you don't even have to necessarily use it as a weapon. It's just the threat of having it in your hand and intending to use it as a weapon, right?
Right. It's just that, having it in your hand and that person, putting them in fear of death or serious bodily injury. I mean, you may have a gun that's unloaded and you point it at someone, for example. It doesn't matter that the gun's unloaded and it's unloaded. It's you pointed that weapon at the person and threatened them, and therefore that's a felony aggravated assault.
Okay, so that's two, and it sounds like I can't really imagine what else there would be, but I think there's more things on your list that qualify as moving something that is a fight from misdemeanor to felony. And what's the next one?
Sure. Strangulation of a family member. That is, you and your significant other get into an argument, and the significant other then claims that you impeded their normal breathing or the blood flow from to their brain, and that's considered a strangulation. And again, whether or not it was intentional, sometimes even if that occurs recklessly, I've had those cases where, all the parties agree it was not intentional. However, it still resulted in the effect of the person not being able to breathe or the circulation being stopped. And that's a strangulation.
All right. So is it a strangulation if the person who was allegedly strangled just says it is, or do there have to be signs?
Well, it can be simply a statement of, he put his hands around my neck, and then the officer says, "Did you have difficulty breathing?" And, if the answer is yes, then you're looking at a strangulation, even though, it may have been, for example, I've had it where the client has just pinned somebody up against the wall, and used force, like right around the collarbone, but not actually strangling. There's redness and evidence of being pushed by the along the collarbone, but because the officer said, "Did you have difficulty breathing?" Then that's, they're facing a strangulation charge. However, it's defensible, because were they having a difficult time breathing because they were upset and screaming and yelling, and involved in this physical altercation, or did they have difficulty breathing because the alleged person, the alleged assault involved an actual strangulation? That would be something that a lawyer would definitely need to look at and determine, is the charge valid?
Yeah. Okay. Well, one area that we haven't quite touched on, I know that, parents have to fight with their kids all the time, right? Sometimes because they're trying to parent. And sometimes that can get physical. It shouldn't probably, but it does. So how is that treated by the law?
Sure. So, this situation, say for example, that we're just talking about, sometimes I've had parents or grandparents that, have grabbed the child by the neck. And so, for whatever reason, law enforcement was called. And, the definition of household member for strangulation, it has to be an adult. So, under the language of the statute, the strangulation would not apply to a child. It would be a felony child abuse in that particular situation. And then, it comes down to, was this reasonable corporal punishment, or was it outside the scope of disciplining the child? And that really is a defense then if that sort of situation happens.
Yeah, so it's a judgment call then about just what was the nature of this type of fight, because parenting is a little different than talking to your friends and adult peers, right?
Right, exactly.
So what is one more thing that will distinguish a misdemeanor from a felony fight?
Sure. So when we're talking about domestic violence charges, so if you have 2 prior domestic violence charges on your record in the past 10 years, and you get a third one, that misdemeanor then gets enhanced to a felony. And, there could be just an allegation that you grabbed somebody or that you pushed somebody, during a fight or an argument. And that would typically be a misdemeanor. However, because you have 2 prior convictions, something that simple can result in a felony.
Okay, so there are 5 different ways that a misdemeanor can become a felony with a fight, even if you don't think it's going to. This definitely involves having a lawyer if any of this comes to pass with any of the people watching this video. So how do they get in touch with you?
Sure, we'll include a link in the description where they can call, text, or chat with a member of my team anytime, day or night. Here at Just Criminal Law, we know you only get one shot at justice, so make yours count.